Welcome to ELI session of summer school this year in basic land use and energy law. My name is Madison Calhoun. I'm the Senior Manager of Educational Programs here at ELI. We're so excited to have all of you today. This series is aimed at folks without a strong background in environmental law. It's an introductory course into the basics and foundational elements of environmental law. So no matter your background, you are all welcome at all of these sessions. We'll have a session of summer school every Thursday through June and July, except for next Thursday, there's not a session. All sessions will be recorded and posted publicly on ELI's website in case you're not able to make it to one. This is the second out of 3 in-person summer school sessions. So it'll be this one, and then as you can see back here, the last one in person will be on July 27th. The rest will be virtual, so 2 weeks from today, we'll be back with our next virtual session, which is on the Clean Air Act. Today's session is on the basics of land use, energy law, and we'll also be talking a little bit about tribal law as well. We will be taking questions at the end, so please hold your questions until everything's finished, and then we will bring mics around to you. Please also remember to speak into the microphones, that way the people who watch the recording back later are still able to hear everything. You can find each individual session of summer school on our website at eli.org. Please reach out to me or events@eli.org if you have any questions at all. Now we can go ahead and kick things off for today's session. In a moment, I'll hand things over to our wonderful moderator. She'll give some opening remarks, and then our 3 panelists will each present. After the presentations, there will be a roundtable discussion, and then, like I said, I'm going to go ahead for audience questions. If we end a little early, there will also be time for networking. With that, let's begin. I'm now going to introduce our moderator, Susan Lafferty. Susan is a partner at Paulson Knight. She focuses on energy and environmental issues impacting petroleum, biofuels, and energy trading industries. Susan is recognized as a leading energy transition advisor on regulatory, commercial, and policy issues related to renewable fuel standards, state low carbon fuel standards, and carbon offsets. She advises clients on compliance issues impacting an array of commodities, including gasoline, ultra low sulfur diesel, ethanol, biodiesel, renewable diesel, sustainable aviation fuel, renewable natural gas, responsibly sourced gas, metals, and agriculture products. Under her leadership, her team has been recognized as having the best practice for North American markets and renewable energy certificates for the last 6 years. I'll hand things over to you, Susan, and thank you all so much for being here today.
Great, thank you. Appreciate that, Madison. Thank you all for being here today and braving this October-like weather. I was very honored to be asked to work with this panel. Especially once I saw the folks that are on the panel with me and their backgrounds. I think it's just a really impressive array, and I'm glad I get to ask the questions and listen with you all. So I'll start with some bios, and then we're going to jump into the individual presentations. So we have Mason Emnett. He is the Senior Vice President of Public Policy for Constellation. Mason leads the development and implementation of federal, regional, and state governmental regulatory and public policy strategies for Constellation, which is the nation's largest producer of carbon-free energy and the leading competitive retail supplier of energy products and services for over 2 million homes and businesses across the United States. He is responsible for identifying and assessing key federal and state policy issues of interest to Constellation, and then crafting the company's position on such issues and developing strategies for achieving public policy objectives. He is also responsible for managing their wholesale market design advocacy in each of the regional markets that he's going to talk about. And prior to joining Exelon, he was also at the Federal Energy Regulatory Commission, or FERC. So he has seen this role both from the government side and now from in-house. We also have Josh Axelrod. He's a senior advocate for the nature program at the NRDC. Josh focuses on issues including public land protection and conservation, renewable energy siting on public lands, limiting oil and gas development on public lands, energy transmission, and climate policy. Since joining NRDC in 2013, Josh has also developed an expertise in oil spill response and preparedness, forest management, forest production, forest carbon dynamics, fossil fuel production, and North American fossil fuel transport. Finally, least but not last, we have Gussie Lord. She is managing attorney of the Tribal Partnership Program at Earth Justice, where she partners with Earth Justice regional offices to increase capacity and expertise in critical work on behalf of tribes and indigenous communities. Gussie has spent most of her career representing tribal governments, individuals, and Native-owned businesses. Prior to Earth Justice, she was at a small law firm here in Washington that specializes in environmental law. She has worked with dozens of tribes and has represented clients in federal, state, and tribal courts and administrative proceedings, and has helped tribes to develop and enforce their own environmental laws and regulations. She is well-versed in issues related to tribal justice, jurisdiction, and sovereignty, and is a member of the Oneida Nation of Wisconsin. So we are going to start first with Mason and listen to each of their presentations, and then, as Madison said, I'll have some questions, but then I'll also open it up for others.
Great, thanks. So if we can go to the next slide. Sorry, I'm gonna turn around and make sure. Yeah. So Mason Emnett, again, Constellation Energy, so as I mentioned, we're a big clean energy provider. So maybe start with a little bit how did I end up doing this stuff? By fluke, largely. Graduated from law school. This was in 1998, needed a job. Interviewed around a bunch of different law firms, did not like the place that I did my second year summer, and so was in third year in the lovely position of looking for a position. And the firm that I was kind of focusing on had 3 spots available: energy regulatory, trade, and tax. Tax scared me. Trade was actually what I was doing the summer before, and I liked the work, but it was pretty narrow, at least the area that I was working in. And I liked administrative law, and energy regulatory just sounded kind of interesting. So let's give it a try. It was a practice that was largely full of former government employees. So this was 1998. People didn't wear ties. That sounded good to me. And within a year, actually it was on my first day, former chair of the FERC, the Federal Energy Regulatory Commission, was the lead of the practice, and came in and asked me, why did I pick them, because as a 1L coming into a specialty practice, it was a little weird. First year coming into energy practice, and I said, well, I gave some answer about how I liked administrative law, and he said, yeah, I didn't know either. I ended up, and then all of a sudden, after like 20 years, I was head of the agency. But what he said then was, it's going to take about a year or 2 before you come up the learning curve, and that's okay, because you need to learn the industry before you learn the law, because the law has built up around an industry. And so that's kind of the way I'll structure my conversation today, is start with a little bit of the framework. We'll kind of, my general topic of decarbonization, dive a little bit into the regulatory structures and the various agencies, but then kind of zoom back out and walk through grid decarbonization as an example of kind of topically moving through the area of energy law within the regulatory space. So decarbonizing electricity, the stack. We've done a pretty good job in terms of over time removing carbon emissions, or making the power grid less carbon intensive. That's really important, because as you look out in the future under really any sort of pathways analysis, lots of people have sliced and diced it different ways. You come to the conclusion that you need a lot more electricity to take sectors that would need to move off of the use of fossil fuel and electrify them, at the same time that you're removing the carbon intensity, or reducing the carbon intensity of the power grid itself, the production of electricity. And so you get this phenomena of an explosive growth in clean energy within the sector. At the same time, you're trying to use that clean energy and decarbonize other areas of the grid. And so that just raises all sorts of implications for an energy system, which largely built up around the use of fossil fuels. And that's the way that the regulatory frameworks were developed. But it is kind of a truism as we look into the future, whether it's the way that the cost recovery structures are set up, whether it's the way that the land use is set up, whether it's the way that energy companies engage with their communities and the impacts that they're having. It's all from my perspective and our company's perspective. You've got to look at it at the lens of what are we trying to achieve in terms of decarbonization, because the electric sector becomes the linchpin for being able to decarbonize the broader community. So if we could flip to the next slide. So within this construct, you have this strange environment where the energy, right? Oh, can you hear me?
If you can speak up just a little.
Oh, yeah, okay. Yeah, okay. Let me know. Is it any better? Can y'all hear me, or is it picking up on that? Okay, hear better? Okay. So you have this little bit of a paradox where the energy sector is being relied, the electricity sector in particular is being relied upon for decarbonization and implementation of environmental policies, but energy regulators are not environmental regulators. The statutes that they operate under do not really even take into consideration environmental matters. So a lot of utility commissions, whether it's at the federal level, the FERC, or the state utility commissions, they were set up decades ago, 70, 80 years ago. And most of the statutory frameworks are written from the context of consumer protection, ensuring that you're providing reliable and affordable service and not taking advantage of monopoly service, not ensuring that you're engaging with the communities and the decisions that you're making, and the regulators overseeing the investment and kind of service obligations of the utilities. The notion of environmental protection or environmental impact of what energy companies do is just, it's literally not in any of the statutes. And yet it very much is in the public interest. And so you have some kind of difficult issues to work through now, where we're trying to take these, in some cases, 100-year-old statutes and apply them in ways to new contexts that just become challenging. So generally speaking, there are two buckets of regulation, one at the federal level and one at the state level, where the Federal Commission, FERC, has jurisdiction over a whole host of things, which you can kind of think about it as interstate in nature. So companies buying and selling power, buying and selling electricity and natural gas, trading at the wholesale level in the commodity that ultimately would be delivered to us as customers. And a whole system of regulation that you can think about, right, to make sure that you don't have any one supplier having monopoly control and therefore being able to influence prices. And so at the federal level, the FERC very focused on ensuring the right set of rules so that the rates for that wholesale power between you can think of company to company transactions are just and reasonable and not unduly discriminatory. That is literally the statutory standard that everything gets decided upon. Just and reasonable and not unduly discriminatory. It's pretty broad, right? It's pretty vague. And so you can interpret that in many ways, but the agency is doing it based on 100 years of precedent, where again, they've been focused on reliability and affordability. Other regulators like Environmental Protection Agency are responsible for the emissions associated with operation of the power grid. And so there's all this precedent basically saying FERC is very limited in its ability to take environmental issues into consideration, even though the decisions they're making have significant impact on the environmental regulations. And it'll be interesting to see in the next session when you all cover the Clean Air Act. Right now, power sector emissions limits have been proposed under Section 111 of the Clean Air Act, and there is a conversation that is happening between EPA and FERC as to the impact of those emissions regulations by EPA on the power market and prices, reliability, and so a conversation happening between the two agencies, but each operating under their different statutory standards and even different kind of structural, I guess maybe governance systems that are important to understand. FERC, like most commissions, is an independent agency. So its commissioners and chairman are appointed by the president, confirmed by the Senate, and all actions of the agency are done by a majority vote. 3 of the 5 commissioners 3 must be of the ruling party, 2 must be of the minority party, or kind of nominated by one of the parties. So then you've got a bipartisan, by definition, bipartisan commission. As commissioners roll off and on, you can end up in weird situations where maybe you have a single party for a certain period of time until the nomination process kind of catches up. But by and large, FERC is a bipartisan agency that makes its decisions based on majority vote. And then you've got an issue like decarbonization and power sector limits, which are being promulgated by EPA under the cabinet or administration, part of the administration, ultimately responsible and answerable to President Biden. And the directives that the administration can give to EPA, go do this, this is the goal that I want you to achieve, they cannot do to FERC, right? Because FERC's gonna decide by vote. And so there's this just disconnect in the federal regulatory structure as to what we might be trying to achieve in terms of national goals, and then the mechanisms by which you can do that. So again, FERC is focused on kind of the interstate transactions, company to company transactions, transmission, so the delivery of electricity, over long distance. Think when you're driving down the road on the highway, you see the big power lines. FERC regulates the rates associated with those transmission lines, the planning process, how you bring them on, but not the permitting. The permitting would be done largely at the local level by, in some parts, public utility commissions, in some parts, other agencies, and I'll hand off for the land use conversation. But so FERC is not a permitting agency for the most part. They do have some statutory authority for backstop permitting that was subject to some legal challenges that ended up getting fixed through some statutory changes, and they're now regulatory proceedings at FERC to try and re-up those regulations to provide a bit of backstop authority for FERC. But generally, you should think about the operation of the transmission lines, the rates associated with it, that's going to be set by FERC. But then can you actually build the thing? Can you get the approval to build it? That's largely going to be a state conversation. So then within the states, they also are very focused on delivery of service, rates for customers, fairness, equity. And in general, the statutes are written a bit more broad, refer to consumer interest, public interest, and the state commissions have plenary jurisdiction over the operation and provision of service from electricity or natural gas companies. And so you've got the state regulators that are focused on end-use customers, delivery and service. So you think you turn on your light, you turn on your stove, you get a gas bill, you get an electric bill, that's all regulated at the state level. What your gas company or electric company is doing in order to get that service, get that commodity in order to deliver to you, that's being regulated at the federal level. And the federal and state regulators kind of talking to each other, but really not so much. And so it's the companies in between that are trying to navigate these regulatory environments. They are all, however, the commissions, they are all, as I mentioned, they're creatures of statutes. They can do what the statute tells them to do, and they can't do anything more. And that becomes important, again, for this intersection of the environmental policies. The focus primarily of certainly the federal regulators, but to a large degree, the state regulators as well, as I mentioned, is reliability and affordability. And they are quasi-judicial in nature. They have to make their decisions based on an administrative record, because again, they operate based on vote. So I mentioned at the FERC level, there's the bipartisan nomination of commissioners. Similarly, occurs in most states similarly. In some states, you have the commissioners actually being voted on, they run for office. And so each of the states are going to have their own kind of, governance structure. But by and large, when you're working on any sort of energy related issues, questions that you should be asking is, what's the scope of the transaction, of the activity that you're looking at, and then thinking, well, who has regulation over that? And probably 9 times out of 10, it's going to be both of those levels, both federal and state. So we can switch to the next slide. So kind of taking these regulatory structures and then applying them to the context of decarbonization. So the economy-wide implications of decarbonizing the power sector, this is a study that the Brattle group did. for New England, stakeholders in New England, largely the states, as they want to try and achieve net zero. Will different slices and dices, 80% reduction by 2050 or net zero by 2050, but just under different versions of decarbonization, look out in the future and what do the New England states need in order to achieve that goal. And it's not just within the power sector, right? Because if you're talking economy wide, it's all the uses of electricity, which are converting from fossil to over to electricity. And that top chart shows the amount of new clean energy you need in order to kind of on average meet the goals over time. And that's the dotted line as it goes up. And then the kind of bars at the bottom is what the New England states have been able to achieve in terms of clean energy additions to date. And that's in the aggregate. And so in the aggregate, they're going to need, a good 10 times the amount of clean energy that they've been able to bring on so far. And so the region's looking at offshore wind, it's looking at solar. Onshore wind is kind of available in some parts, is looking at trying to get hydropower from New England. But there's this kind of conversation that's occurring just physically. How much clean energy can you get on the system? And then you got to squeeze it through all of the regulatory systems to figure out who's going to pay for it, if it's got to be permitted, who's going to approve it, and then actually get to planning, construction, and operation. Down at the bottom are just some charts which as you think about where money is coming from for all of these projects. It is by and large, and this study was done before the Inflation Reduction Act, which continued and expanded production tax credits for wind, solar, and other clean energy, added for nuclear, added for a bunch of new emerging technologies in the clean space. So this was just a snapshot based on state dollars for clean energy. On the left, you can see growing over time. This is a kind of a snapshot from 2017, 2018, looking forward until kind of 2028. The growth you're moving from about 20% of the dollars for a project coming from state funds to about 50% of the dollars. So again, you go back to that conversation about, well, who's regulating what? And if what the federal regulators are doing is ensuring that a market is in place for the trading of electricity, but then the states are coming in and throwing more and more money at individual projects. How does the federal regulator think about that in terms of fairness and equity in wholesale trading when you've got some resources that are getting money and other resources that are not? And we'll go into an example on that in a minute. And so then on the right side, that's the amount of money that a new combined cycle natural gas, so think of like big natural gas power plant. That's the amount of money that they are otherwise receiving from the market under these various projections. And it's basically, dropping by about 40% over the same time frame. So yes, it's important that we're expanding clean energy, but we also need reliable sources of power, including some operation of natural gas. And the natural gas folks are looking in the market and saying, well, you're giving more and more money to clean energy. You're not giving any to me. How am I going to stick around? Why am I going to stick around when my revenues just, got cut in half? So again, that becomes a conversation between the federal regulators and the state regulators. So we can switch to the next slide. So geographically, there are also disconnects. So as you think about electric utilities, most of them, and this is a map from Edison Electric Institute, which is the Association for Investor-Owned Utilities. There's a similar map for municipally owned utilities. So publicly owned entities, cooperatives, is municipal entities, the way that people kind of generally refer to them. And so this is the kind of private version. There's a public version, but the public version, the private version, the investor-owned, kind of highlights a different difficulty of a lot of the electric companies operate across state lines. And so they are managing disconnects in regulatory frameworks where they're trying to make a decision, how am I going to invest my capital, and what am I going to achieve, and how am I going to achieve my own decarbonization targets over time when they have individual states engaging that regulatory conversation of what you're allowed to build, what you're allowed to charge for it, and who you're allowed to charge for it on an individual kind of disaggregated basis, while then the federal government is sitting on top of it, trying to look across and create kind of fairness and equity in the wholesale market. Which takes us, we'll flip over to the next slide. So the way that FERC approaches this issue is through regional markets. That there are 6, 7 kind of large regional markets within the United States where that wholesale activity, the companies to companies trading in electricity, is occurring at, these are called regional transmission organizations or independent system operators, RTOs or ISOs. You will hear people refer to them when you're in this space of, regional operators, RTOs, ISOs. But the general concept here is if you're in one of those markets, SPP, Southwest Power Pool, ERCOT, PJM, New York ISO, ISO New England. If you're in one of these colored buckets, you can kind of fungibly trade in your product, your electricity. And the grid operators are managing and dispatching generation within these footprints on a kind of moment to moment basis. And so the grid operator can see all generators operating within its footprint. It can see all large users of electricity. It can see all utilities, and it's constantly balancing the system through a market mechanism and through auctions, and then billing out customers. And so this is the way that FERC, through its regulatory framework, says, okay, I'm responsible for ensuring just and reasonable rates in this wholesale trading activity. I will do that by setting up markets where you can trade. And so I'll make sure that within each of these markets, there's no one dominant seller who's able to kind of gouge the market because of their market presence. And I'll ensure at the end of the day, we've got reliable service and that the price for electricity is not too high, but does not take into consideration, too high based on what? Based on achieving state goals with respect to decarbonization. We don't have federal goals with respect to decarbonization. We have federal incentives for clean energy, but the FERC, the federal regulator, has not been charged with ensuring that those clean energy projects come online. And so it's responsible for the transmission in these bubbles as well, right? Are we getting the right transmission, and is it affordable, and is it reliable? But does it achieve our clean energy ambitions? Well, the agency doesn't have clean energy ambitions, and it's a bipartisan agency where there are very firm differences of opinion among the commissioners as to whether it's appropriate for the agency to be even asking questions about achieving decarbonization. And so you're in that environment where then EPA and other folks at the federal level are trying to implement regulations to achieve a certain thing, and there's this just natural friction. It's a governance system-based friction that is going to be there and will persist until there's some sort of federal, if and when there's a federal directive with respect to decarbonization. So we flip to the next slide. So this disconnect kind of came to a head in a few years ago, and it's a kind of a good example to pause on. In the PJM market, which was on the prior slide, the Mid-Atlantic region, kind of 13 states in the Mid-Atlantic region, all within a single market. And about half of their states have clean energy policies. And so you think of that back to that New England slide, the growing amount of state money going into clean energy resources, kind of same thing happening within the PJM region. An increasing amount of money come from the states into the basically the electricity generators that are participating in this market, providing more and more support from them out of the market. FERC having responsibility for ensuring fairness and equity and competition in this wholesale market. How am I going to do that? And so the way that they decided to do it under a Republican-led agency is to implement something called the minimum offer price rules, an administrative construct to say, look, if you're coming into my market and you're getting money from the state for clean or whatever, I don't care. I'm going to take that out of your offer in my market. I'm not going to allow you to consider that revenue because it's not fair. It's unequitable to the other generators who aren't supported by the state. And my responsibility is to ensure just and reasonable rates in a competitive market. So what does that do? It makes the clean resources look more expensive because they're getting revenue from the state. They can't take that into consideration when submitting their offer, and they start getting priced out of the market. So the wholesale market mechanism through the FERC regulation is saying, I recognize that the clean energy resource is going to be operating because the state's paying them to be there, but I'm not going to buy you in my market mechanism, and I'm going to buy fossil to replace you. So it's just a direct conflict with what we're trying to achieve in terms of decarbonization. And it was all in the context of competition policy, but it had such an impact on trying to achieve, what the states have laid out in terms of addressing the decarbonization challenge. And it's just through, a quirky regulatory proceeding at the federal level for a sleepy regulator who oversees the wholesale electricity markets. Now, this policy was ultimately undone. There was a change of administration. The Democratic-led agency unwound this provision, but it's like a classic example of the disconnects that you can have within the regulatory structure because there are competing considerations, and those competing considerations go to the underlying statutory frameworks, which don't explicitly acknowledge the decarbonization challenge that we have before us, and therefore leads to, I would call it mischief, but the folks who sit in different positions, we have different concerns that we're trying to address, right? The Republican-led or the Republican chairman of FERC at the time had one set of concerns. The Democratic chairman, later in time, which was unwinding this policy, had a different level of concerns. And you can just look at the same problem and see them differently. And we need some clarity in our statutory frameworks to resolve that. So sorry, I'll speed it up. The last couple of slides just walk through. So if we think forward, how could we address this in a way how could we address this disconnect in a way that also tries to harmonize the disconnects at the federal and state level in terms of regulatory frameworks? And there are three general ways to do it in the electric sector. You can do it through carbon pricing. So put a price on carbon emissions. And this occurs within a number of states. There's something called the RGGI, Regional Greenhouse Gas Initiative, and out in California in coordination with Canadian province implementing and actually expanding now to some of the other Western states. Implementing adding in or forcing emitting generators, so fossil generators, to pay an allowance to pollute. And so this concept exists, in other environmental contexts under EPA regulations, but it doesn't exist universally in the power sector. Some states have adopted it. Generally speaking, the states that have implemented carbon pricing have done so in a way that doesn't significantly impact the power prices, the offer in the electricity market, just because of the way they've set up the programs. And it goes back to that disconnect of, well, if the state has control over its individual state, it doesn't necessarily want to competitively disadvantage its companies operating within that state, because all that's going to do is drive up the cost of electricity for the customers in their state, and they aren't necessarily going to achieve their goals, because when you're operating in a 13-state region, you're just going to shuffle things around within it, right? Because everybody is available to provide the supply within that market. And so if there were the kind of collaboration and coordination between federal regulator and state regulator to come together and say, we have our independent jurisdictional authorities, and we want to establish a framework that is market oriented for you achieve your goals, but we're achieving our emissions reduction goals. That is certainly possible. It doesn't happen. This is also a potential option at the federal level to kind of cut through this regulatory framework and say, this isn't a regulatory decision anymore. This is a market decision, and we're just going to apply a carbon price, and everybody at the federal state level, that's what you're going to live with, and you will implement it and integrate it into your regulatory structures. And that's politically not really feasible. So if we flip to the next slide, what's really happening is states are coordinating with themselves. States have jurisdiction over the resource, the supply stack, what companies use to provide their service. Because again, the states have the ultimate jurisdiction over the service to customers when we flip on the lights and turn on the gas. And so the state commissions can say, company, I want to understand where you're getting supply, and have a conversation about that and say, we'll get more of this buy less of that. And so states are starting to coordinate with each other on that and achieve some efficiencies. That creates its own problems, though, because they're coordinating with themselves in a wholesale market, which is subject to FERC's regulation. And so I can't get crosswise with the regulatory structure that FERC has set up. And so there have been some cases where some of these state programs have been thrown out on preemption grounds because the state is deemed to be setting the rate for that company to company transaction, and they don't have the authority to do that. And then flip to the next slide. So last option is, okay, well, if the federal government has through FERC, they've got the jurisdiction for these company to company conversations. Well, then let's turn it over to them. So the states go to the federal regulator and say, here's what I'm trying to achieve. And you, through your market mechanisms, achieve the thing that I want to achieve. That largely, and the three regions up here, the New England, PJM, and the 13-state Mid-Atlantic region, and that's New York. New York is referred to as its own region. It's because it's a quirk that sits in between the other two. And that becomes difficult because you're asking the state to take its goal, what it's trying to achieve in decarbonization, and give it to the federal regulators and say, I trust you to get it right. And so far that hasn't happened. And back to the kind of governance issue where you have an agency at the federal level that's swapping back and you're flipping back and forth between Republican and Democratic control, you kind of don't see it as reasonably predictable in the future either. And so flip to the last slide. We're left in this situation where because of the governance structures, the literal framework of regulating the electricity industry, you have this almost unresolvable tension where the companies, the folks like us who are, wanting to support the preservation and expansion of clean energy, we're operating in this environment where if we got agreement between the state and the federal government, the federal policy, I wouldn't even say government, because that implicates kind of administration versus FERC, then looks like things are kind of good. But if you're in a state where, take a state like Pennsylvania, so you've got the governor who is supportive of decarbonization, supportive of long-term policies, but a legislature who is not and is fighting the state's participation in one of the carbon pricing programs. We own lots of clean power within Pennsylvania. And so that makes it a very awkward dynamic when we want to be expanding, what we do. We want to be working with a federal federal regulator in terms of progressive policies. We'd have support from the governor, but the legislatures, not so much. And they're going to oppose most any decarbonization policy moving through the state. And that's just the nature of the beast within the energy regulatory framework. Every state is going to kind of answer these questions differently. And there will always be a federal state kind of conversation in pretty much anything that you do that you touch the space. So that hand over to land use.
All right, thank you, Mason. Great. Hey, everybody. I'm Josh Axelrod. I'm a senior policy advocate at the Natural Resources Defense Council, or NRDC. So just going to outline my presentation quickly. I work mostly on policy and not directly on legal issues or litigating. And so I'm going to kind of try and bridge the gap between a very small sliver of the land use laws and how they are getting applied via some recent updates or proposed updates to regulation, and then some examples of kind of the ways that an advocacy organization like NRDC is pushing to have those regulations or those laws implemented on the ground when you're citing renewable energy projects. So with that, next slide. So what that's going to look like is, can you do next slide? And if you can't hear me, please tell me. I'm really soft-spoken. I have no sense of my voice volume. So I'm just going to quickly walk through a little bit of the Federal Land and Policy Management Act, which is known as FLPMA. I'll call it FLPMA because it's so long. Title V is where the authority is granted to the Department of the Interior and the Bureau of Land Management to cite renewable energy projects on public lands. And then I'm going to, just last week, there were some updates announced a new proposed wind and solar rule, or an update to the rule, and the kind of revealing of the first stage of the revision for the basically Western states solar programmatic environmental impact statement, which is being updated from its 2012 version. So I'm going to cover those, and then I'm going to shift gears to kind of look at how, like, what NRDC and a lot of organizations refer to as smart or responsible siting, and how that works. And the first thing we'll look at is a proposed piece of legislation that's been around for a long time, that's kind of a model for what that might look like if it were ever implemented via a law. And then just a really quick case study of kind of an effort that was done in Oregon to craft a voluntary set of guidelines for smart siting that developers could choose to follow, and the theory behind why that might be a good idea to have out there or not. And then, if I have time, some challenges that map to some degree to a lot of the tensions that Mason covered. So with that, next slide. And I apologize, I did not know that my slides would be behind me, so I'm going to just read a little bit of this on my phone. But so I just want to start with FLPMA and kind of its the congressional statement of purpose for the law when it was passed in 1976. It's very aspirational. It's like a beautiful piece of language, but it gives you a sense of kind of what Congress was trying to, the kind of powers that Congress was trying to give to the land management agencies at that time. And so basically it declared a national land use policy that is meant to ensure that management be on the basis of multiple use and sustained yield, that land be managed in a manner that will protect the quality of scientific, scenic, historical, ecological, environmental, air and atmospheric, water resource, and archaeological values, and that our need for domestic sources of minerals, food, timber, and fiber be supported by these lands. Oh, wow, another screen. And so, you know, very aspirational, very wide net. That language can be interpreted 1,000 ways, but it does lay out, you know, a view of what the public lands as they are, what they're for, and how they should be managed now and into the future. And then under FLPMA, there is Title V, and Title V conveyed authority for renewable energy siting, and specifically under Title V, BLM can grant rights of way to public lands for systems for generation, transmission, and distribution of electric energy. And then the rest of Title V basically just explains how the agency can grant and administer those rights of way. And that's the system that exists. You know, in 1976, there wasn't a lot of renewable energy interest on public land. There may have been some geothermal at that time, certainly not wind and solar. And the law has not changed very much since then. And the whole right-of-way system is very different than other laws that guide development on our public lands. And I was originally going to talk a little bit about this, but I just don't have time. That I would encourage you, if you're interested, you know, to look at the laws that guide oil and gas in our federal in the federal space. So you have the Mineral Leasing Act for onshore, you have OXLA, the offshore, the Continental Shelf Leasing Act. You have a specific law for Alaska. All of those are very specific on oil and gas. They have very specific terms, very specific timelines for when the agency should consider leasing, how permits are issued, the costs of things, they're set in stone, even as things have been amended. Similar case with minerals under the General Mining Law, which is from 1872. And you know, it's extremely permissive in terms of use of public lands. But here with renewable energy, the law is very vague, and it carved out the space and kind of left it there. And so what we have is kind of a bit of a mess and a bit of a slow start in terms of using the federal lands as part of the kind of as part of the solution for decarbonizing things. According to the BLM, doesn't keep particularly up-to-date statistics, but the generally cited statistic is that there's currently about 13 gigawatts of energy built on public lands or sited and permitted on public lands. The goal under the law and by the administration is to reach 25 gigawatts sited and permitted by 2025. That 13 gigawatt number has it's not really changed for 4 years, 5 years. And so, but there are a lot of projects in the queue. And so what the administration is recently proposing, if you go to the next slide, is some updates to the regulations that apply to wind and solar projects that are sited on BLM managed land. So the general, in terms of why there's suggesting changes. First, they were given additional authority to make some of these changes by the Energy Act of 2020. And then the second reason is they're hoping that the rules will lower costs for developers and provide greater certainty. And the certainty piece really comes in the fact that under the rule, rights of ways, which are either issued as a lease or a grant, will now have a term of up to 50 years. And so that creates kind of a certainty in terms of you will have access to use that land for the purpose that you're proposing for, the presumed lifespan of these projects, which are, quite significant. To contrast that with oil and gas, leases are usually 10 years and can be renewed for 10 years. And there are some other ways that they can be extended, but 50 years is very substantial in terms of a grant for use of the land. So that is a significant change. And otherwise, a lot of the terms are about reducing costs. So a kind of persistent problem with projects on federal lands to date has been the rental fees. They get figured via this database that basically classifies the value of each acre of land in each state. And some projects were located in areas with really high acreage values, and that became their rent. So you had a few, I think there's just a few, but a few projects that had, acreage rents of in the thousands of dollars per acre. Under the change, the BLM will use a state average, and they say that will lower the rent to like between $2 and $12.60 per acre. So that's a very substantial reduction to kind of the maximum amount, and to some degree harmonizes with the types of rents that other extractive industry, especially oil and gas, pays. They're under the Inflation Reduction Act. Those rates were recently changed, but they now have a floor of $3 per acre, rising to $20 an acre. So it's kind of in the same range. And then in addition, the big change is this idea of reducing or adjusting capacity fees. So capacity fees are, to my mind, largely the same thing as a royalty. It's a fee that you pay per megawatt hour generated. And under the proposed rule, those fees will be reduced by 80% through 2036. That's a very long formula about how you figure them, but there will be that formula. The outcome of that formula will be reduced by 80%, and then after 2036, it'll be reduced by 20%. In an effort to increase, I think, competitiveness of federal land as a location for new projects and to bring in more projects and have them compete with each other as well. And then there's a few additional changes. If your capacity fee exceeds your rent cost, you don't pay rent. And if you build a project with a certain percent of material that qualifies under the Buy American program, you get an additional discount. So there are all these kind of mechanisms that BLM is using to try and lower the cost of building renewable energy projects on, well, in this case, wind and solar projects on federal land. A few other things that touch on where I'm going next is this better direction for establishing designated leasing areas. So designated leasing areas are kind of the areas preferred for development after applying a number of considerations and screens. And so under the proposed rule, some additional factors to consider have been proposed. Importantly, access to transmission, and then whether the lands have low potential for conflict with other resource values. And those kind of things are things like species habitat, freshwater resources, cultural value, this historic preservation considerations, recreation value, etc. All things that are important to kind of recognize upfront before a project gets proposed for an area on the landscape. And then finally, with the kind of improved establishment of these designated leasing areas comes a process for prioritizing review of projects located in them, because again, another challenge that we're having everywhere is building enough fast enough, and there's a lot of effort to figure out a way to grant priority or give priority and incentivize development in specific areas by giving this type of priority and ideally faster review. And just because things have changed a lot, the rule finally formally acknowledges and has some guidance for energy storage facilities and kind of the terms of right-of-ways for high voltage transmission lines, because it's anticipated that a number of those will need to be built. So it's a significant start, I would say. I think it's important that in the absence of major legislative change, either in the land management space or for renewables or for other types of energy, fossil energy, that at least harmonizing kind of our development landscape so that those competing land uses and competing priorities can actually compete with each other is useful. And if we could go to the next slide. And then to kind of support this, another effort that was kicked off around the same time, December 2022, is a revision of the BLM solar PEIS. So if you look at this little map, the original 2012 programmatic PEIS covered the six southwestern states. The basic gist of the change is that they want to expand to the whole West. And this is for solar, so it adds the five northwestern states. And then it's what they've revealed right now is this matrix of 5 action alternatives. And most have to do with, do we prioritize development near transmission? Do we prioritize it on disturbed lands? Do we and there's one other, and then, or do we do that and have a secondary process that allows developers to propose projects on non-preferred lands, but we still have a process for that, and we will process those applications. That's very likely, I think, where the agency will go, because my experience with industry is they want as much flexibility as possible. The being told exactly where the agency wants projects to go has not resulted in projects going into those places. And so my guess is the rule will remain, or that the kind of preferred action alternative will be as flexible as possible and very likely to expand to all 11 states. And part of that is because what's not covered here is wind energy. Wind energy has its own PEIS that was done in 2005, and it applies to all 11 of these states. And at the time that was done, they analyzed 21 million acres for potential location for wind energy. And that's still kind of the guiding document for how the agency considers where to put projects or where to approve projects and how to manage them. Obviously, a lot has changed since 2005. And my guess, I haven't heard that the agency is looking to update this imminently, but it probably should. That the technology has changed a lot. The landscape has changed a lot in 20 years. But that being said, the two kind of management areas will be harmonized by this effort for solar, which brings me to my next slide. So all of that is kind of some very quick background on some of the dynamics that go into how the agency, the power the agency has, where it comes from, some of its regulatory provisions to make development happen on public lands, but the question of how to do it well, how to avoid conflicts, how to avoid serious environmental harm is where a lot of the advocacy work is done. And so the big thing that NRDC pushes for is the concept of directed development. We call it SMART from the start. I think we started calling that about 15 years ago. And a lot of that has found its way into agency policy, a little bit into law, a little bit into regulation. But the general idea is that you should do landscape level planning because at that landscape level, you can better assess kind of all of the values that are out there. What are the impacts of these of landscape level development, across many states? What is the impact of building, large scale interstate transmission? All of these things, and it avoids kind of the pitfalls of doing that on an ad hoc site by site basis, where you kind of fail to take into consideration cumulative impacts. It also, because you do this really wide scale assessment, ideally it guides development to low conflict areas because you've identified the areas of great ecological value, you've identified, endangered species habitat, you've identified, you've spoken to communities, which communities are supportive or what kind of concerns they have. And that leads you to kind of screen out all the stuff that is going to create problems if you try to cite a utility scale project there. Because it's important to remember these things are massive. So they're not small. You will see them if you live near them. If you recreate near them, you will likely see them. And people have a lot of opinions about that, as they should. And so, the idea of directed development is that not only do you end up with development in the best possible place, but you also hopefully increase conservation because you have identified kind of the ecologically sensitive areas that just should be off limits to that development. So next slide. So I just wanted to quickly cover what would that look like under the law, if there was a law that did it. So one proposal out there is called the Public Land Renewable Energy Development Act. This law has a fascinating history if you worked on it. It has been proposed for at least 12 years. It has historically been a strongly bipartisan bill. And for whatever reason, it just can never find a home in a larger legislative package. So it's passed out of committees in both the House and Senate. It's gotten very close. It's been attached to various large packages that did pass, but it always falls out. But the idea behind it is it has a lot of similarities to the current wind and solar rule in that it uses a priority area system, which is basically the same as a designated leasing area. So it basically would direct the agency to use a number of factors to find low conflict areas and designate those as priority areas for wind, solar, and geothermal energy. And then if you were a developer and you proposed a project within one of those areas, you would receive permitting preference. The big change is that it creates a revenue sharing system so that those rents and capacity fees that are currently charged by the government and go into the treasury, some of that would still go into the treasury, but like oil and gas royalties, a lot of it would be redistributed out to the states and counties that host these projects. That can be very controversial, but the idea behind it is that one of the big problems that renewables continue to have on public lands is that oil and gas has a huge economic incentive for state budgets. So some states are incredibly reliant on that funding, and renewable projects do not bring any direct payments from the government if they're exist in your state, and obviously they come with the landscape impact that some people don't want. And so this is the idea here is that, again, better harmonization between those two systems and rebalancing the incentives. And then there's some provisions basically to set aside money for conservation and mitigation of impacts. ensuring that if you were to build a project, that access to public land is preserved or enhanced. So it's a a good attempt. I think it's definitely a compromise piece of legislation, but it is a pretty strong in terms of directing smart, thoughtful development, and maybe it will be passed someday. We'll see. So let's see if we can go to the next slide. Just to wrap up. So recently there was a multi-year effort in Oregon to come up with voluntary siting guidelines. And the idea here is that, so first, in 2021, Oregon passed a 100% zero emission electricity goal that with the mandated date by 2040. The political will is there in Oregon, but there are enormous challenges to actually meeting that goal for a number of reasons that I'll maybe touch on. But so this project came along to kind of gather as many viewpoints and pieces of input and as possible into what people think about renewable energy in the state, the kind of challenges that might exist, the kind of conflicts that might need to be addressed, and to really distill that then into a best practices approach that, if a developer was coming into Oregon or working in Oregon, might look at those, the theory is they might look at those guidelines and be like, okay, this is a good roadmap for approaching this project and actually getting it built. And so what I'm going to do is just kind of give you a sense. I like with Florida and the slide about directed development, those are very high level. I'm just going to give you a sense of like what really specific, more specific maybe citing guidelines would look like, that all the things that you want to look at. The kind of key takeaway is that community engagement early, often, constantly is key. Communities really dislike a sense of surprise, even if they aren't actually surprised. And I will say I'm actually from Oregon, and there's a huge transmission line that's proposed through my hometown, and the perception there, and it crosses political boundaries, it crosses ideological boundaries, everything. Nobody likes it because it goes through the city's viewshed in a very scenic place, and they feel like they didn't know about it until it was already being, considered by FERC or had basically been agreed upon. But because of that, it has now hit enormous opposition and slowdowns, and who knows if it will ever be built. Community engagement is key, but then, a number of factors are also critical. Again, is there a high resource potential? Is this a good place to build wind and solar? What's the access to existing transmission and distribution? Are there low biodiversity conflicts? Would the area conflict with agricultural production? That's really key in a number of states, especially Oregon. Are the areas where the projects would be located, do they minimize conflicts with communities, cultural resources, and historic values? Is the area, does it have low recreational and scenic value? Does the area overlap with military operations, another huge issue in the West? And does the area impinge in any way on tribal sovereignty? Some tribes don't want, for example, as in Oregon, don't want wind turbines visible from their land, which is totally fair because it can be seen from a long way away. And so, I think with that, if you want to go to the last slide, I think the general message is there is a lot of opportunity, and there's a lot of work being done to not only build more renewable energy on federal public lands, but to build it right. But that being said, there are so many conflicting uses and interests. You have very significant land use impact. You have very significant land use change. You have very cultural values, scenic values, historic values, ecological values that all need to be managed for a project that's going to sit on the landscape for a long period of time. That being said, it's also important to remember that our current kind of energy development scheme has very long lasting land use impacts. very widespread land use impacts that are, they're just different. But you know, I think there's a bit of a false equivalence argument going on in terms of energy transition, and it's hard when you have something, you know, visible. This is the Ivanpah reflective generating situation that's massive, right? And you can see it. With oil and gas, for example, you can't necessarily see as much of it. You see a lot of pump jacks, but you might not see what's happening. You don't see what's happening below the surface. And so you have this sense, I think, with renewable energy that because it's so visible on the surface that, you know, yikes, we need to be really careful and go slow, and maybe we can't build that much or as much as we need. But remember that our kind of historic legacy of land use and land use impact is quite significant and still growing. And balancing all of that out is important. With that, I will pass it to Gus.
Good. Thanks, Josh. As Susie mentioned, my name is Gussie Lord. I'm the managing attorney of the Tribal Partnerships Program at Earth Justice. We're like NRDC, we also are an environmental advocacy organization. My program and my team focuses mainly on litigation on behalf of tribes and indigenous communities across the country and a little bit internationally. I'm going to give you a little bit of an overview of federal Indian law today and how that might impact land use, environment, and energy. And just a caveat is we're going to very slightly touch on energy. That's not my area of expertise. But there are specific issues that impact Indian country differently, and some issues on public land that might have federal Indian law implications. Oh, one more quick thing. I have my email address there. For those of you who are law students, my program puts on a quarterly information session for people who are interested in learning more about the intersection of federal Indian law and environmental laws. You can email us there. Next slide, please. So federal Indian law overview. I like to call this 250 years of Indian law in 10 minutes or less. So we're gonna run through it. Federal Indian law, that's all it is that's the relationship between the federal government and tribes that the federal government recognizes as sovereign governments. So there are other tribes that are not federally recognized. Federally recognized tribes have specific legal rights and standing in ways that other tribes don't, or just indigenous communities don't always have. And the terms tribal sovereignty just means that tribes have the ability to govern themselves, the right to make laws, and their citizens comply with those laws in areas where the tribes have jurisdiction. So it's very important to understand that tribes are political bodies. This relationship exists as a political classification. Tribal citizenship is a political classification, not a racial classification. And tribal sovereignty is inherent. It wasn't bestowed upon tribes by the federal government. It's inherent to these tribes. They predate the federal government. They predate the United States. It's been limited by the federal government. All tribal members and tribal governments are subject to the authority of the federal government. So there's not like operating outside of the sphere of the federal government. Everybody has to comply with, for example, federal environmental laws. But tribes are generally not subject, with some exceptions, are generally not subject to state laws, particularly within their jurisdictions. Congress has plenary authority over tribes. That's written into the Constitution. Congress has the authority to regulate commerce with Indian tribes, as we learned last week in Holland versus Brackeen, or Brackeen versus Holland. And they also have authority under the treaty clause to treat with Indians. So I think the last treaty was in 1871, so we don't have those going on anymore, but we do have treaty rights that are still in existence, and tribal treaty rights are on par with the Constitution, with federal laws, and they are considered to be the highest law of the land. So off-reservation treaty rights in particular can be very powerful in situations when you're, for example, citing a renewable energy project on federal land. There are currently 574 federally recognized tribes. The bulk of those are in Alaska. I think there are 228 in Alaska, and I think there are another 110, 112 in California. So those are that's almost half the tribes. As you'll see here, most of the tribal land, most of the Indian reservation land is west of Mississippi, with some exceptions in the upper Midwest and a couple other places scattered throughout. But the big, huge federal tribal land bases are largely in the Western United States. The way that the reservation system was set up is that those lands are owned by the federal government and they're held in trust for the benefit of tribes. So for the most, tribes can own land, but for the most part, these trust lands are federal lands that the United States is holding for tribes, and they can't be sold for the most part. Next slide, please. So what does this mean? How does federal Indian law come into play in environmental and land use situations? So because the federal government is a trustee to tribes, it has a fiduciary duty of care. So anytime a federal project, something that requires a federal permit, something that happens on federal land, something that happens on tribal land, something that's paid for with federal money, that requires that agency making that decision to consult with an impacted Indian tribe. So they've got to make sure that they're not making decisions that are going to have a negative impact on those resources that they're holding in trust. So that's where you hear the term government to government consultation, the tribal government and the federal government consulting with one another. It's supposed to be well prior to the project, so you don't get a situation like Josh mentioned where it's sort of like already done and then, oh yeah, we're going to consult with you to see how you like it. That happens a lot. And it's supposed to be meaningful consultation. So if the tribes have an opposition to a project or have some input into, this is going to affect our resources in these ways, the federal agency or the decision maker is really supposed to take that into account and try to minimize or mitigate those impacts. That's a requirement under executive order. So they're, basically the federal agencies are required to have a consultation policy. There's no required outcomes. They're required to follow that policy. But there's not, sort of like the National Environmental Policy Act, there's no determined outcome. If a tribe opposes a project and the federal government considers that opposition, then they've met their obligation. Right now, under the current administration, there's been a lot of consideration and a lot of movement with regard to how we're going to incorporate Indigenous concerns, how we're going to incorporate tribal concerns into federal policy. So a lot of the agencies are updating their consultation policies now. EPA, Army Corps of Engineers are updating these right now. And they're also determining, this is new under the Biden administration, they're determining how to incorporate traditional ecological knowledge into federal land management, land use decisions, federal policy, federal regulations, and sort of how the agencies are going to make land use decisions on the ground. So this is really interesting and really exciting development for those of us who work in this field. There's some questions about how that's going to be implemented, how that information is going to be gathered. It's not like there are these huge, ancient tomes of tribal ecological knowledge laying around. How do you find this information out? Well, it's going to depend on where a project is going to be cited, who is interested, where those people are, how are you going to gather that information? How are you going to, get people to talk to you, federal agency person, and tell you their ecological knowledge? How are you going to, how is that transfer of knowledge going to occur? Sometimes there are sensitivities, cultural sensitivities on how certain information can be conveyed and to whom, where certain resources are located and how they're used and when. And a lot of times, once that information is provided to a federal agency, it's not protected anymore. It's anybody can access that information, and so anybody can access these sites, go looking for graves and artifacts and things like that, or be at a place at a certain time. And so a lot of times, people who are still engaging in these traditional ecological practices don't necessarily want to provide that information. So it's very, very interesting and exciting to think about how traditional ecological knowledge can be incorporated into federal land use management. But it's also a little bit of a conundrum on how we're going to get that information, how it's going to be protected, and who's going to own that information. So that's something that's going on now. And there are also a number of states, particularly those with significant tribal populations, that have state consultation policies or state requirements that might pertain to public lands, cultural resource protection, grave protection, things like that. Next slide, please. So tribes as governments have the authority to develop and implement their own environmental laws. Again, that authority comes from the tribe itself. And they also have authority that's been delegated by Congress under the major environmental statutes, the Clean Water Act, the Clean Air Act, Safe Drinking Water Act, and a couple others, where tribes who apply can be treated as a state for purposes of that environmental statute. A good example is the Clean Water Act. If tribes want, they can develop their own water quality standards, and those apply on reservation. And so if it's an act that's occurring on a reservation, if it's a facility or an industry that's developing within a reservation, they have to comply with tribal environmental regulations. But if it's something that's off reservation, that might be a little bit ways away from the tribal government's jurisdiction, but might be impacting on reservation resources, things like water, that those tribal requirements can be incorporated into federal permits or state permits, like a NIPD's permit, a water discharge permit. For example, recently we saw the Army Corps of Engineers pull approval of the permit for the Polymet mine in Minnesota because it was going to impact the Fond du Lac band's water quality standards, on reservation water quality standards. And so because the tribe had those on reservation water quality standards, because the EPA had approved them, they had gone through those processes. When industry came in off reservation, they were barred from getting that permit and emitting into the tribe's water quality standards. Now that just happened. Remains to be seen how this is going to play out. But I think that was the first time that's happened. So it's the first time a tribe has been able to protect its on-reservation water quality standards from off-reservation actors through this mechanism. So it's definitely got major implications for even off-reservation industry, even if it's not on federal or state land, even if it's on private industry. If you need a permit, it could be implicated there. So for tribal law on reservation, through a series of cases, it's been determined that tribes don't have jurisdiction over non-Indian actors in general, subject to two exceptions under the case Montana versus United States. If that actor has sort of entered into a relationship with the tribe, like again, if it's an on-reservation activity and they need to get some tribal permits, they're basically consenting to tribal jurisdiction, so they will have to comply with tribal regulations. Or if it's an activity that threatens the health and welfare of the tribe, and that's been interpreted very narrowly. It's got to be like an existential threat to the tribe's existence before the courts will find that that exception applies. But it has been found to apply in some situations. So some federal environmental laws apply a little bit differently in Indian country. Josh was talking about FLPMA, the Federal Land Policy Management Act. That doesn't apply to Indian lands. So it applies to federal land. It explicitly carves out Indian lands from the purview of that act. And then some legal schemes like oil and gas development and some others, mining, don't necessarily apply to Indian country either. And those are governed under other statutes that are specific to Indian country, Indian Mineral Leasing Act, Indian Mineral Development Act. And it's interesting because the sort of incentive there is to maximize the extraction, maximize the use of these resources. So a lot of times it drove development to Indian country, and that's where you get some of these environmental justice implications, where some of these heavily polluting industries were intentionally cited in Indian country, and it's written directly into the laws. And that's again distinct from FLPMA that has this beautiful language, like you mentioned, that talks about all the different uses of federal land. Not so always in Indian country. Next slide. So I'm talking pretty fast. I'll slow down a little bit and let me know if you can't hear me. So where this comes into play on federal lands is in the NEPA process, and especially if a project is going to impact some sort of cultural or historic resource that's important to a tribe. Then that brings in the National Historic Preservation Act. NEPA doesn't explicitly require tribal consultation. Again, that's through those federal policies that are required, for the executive orders that require each agency to have a consultation policy. They're required in the CEQ regulations, and then NEPA does require compliance with NHPA, and NHPA does have a specific tribal consultation requirement under Section 106. So that's cultural or archaeological resources. Again, there's a little bit of a disconnect between what's protected, what's legally protected, and often what tribes think should be protected. There's not this separation always in Indigenous culture between the environmental resources and the cultural resource, or the environmental resource and the archaeological resource. Like a lot of times tribes consider that to be sort of one and the same or inseparable. So sometimes tribes will say, well, we don't want, this something impacting our view shed. Well, maybe we can think about that, but it's not explicitly protected. There's not a limit to how much a project can impact a view shed, or how much light can impact an area, or how noise can impact an area. Again, those things can be sort of part of a consideration, but sometimes just like the feel of a place or the essence of a place or how that place is used or has been used for millennia is just not necessarily protected, particularly on the environmental statutes. So sometimes things can fall through the cracks. Things that are important to our clients often don't have real strong legal protections, particularly when it's off reservation on federal land. Again, these only apply when it is a federal undertaking or a federal project or funded by federal money. So I want to go through, next slide, please. So I want to go through some sort of current issues that we're seeing under the Biden administration in the land use arena. One of the things you might have heard of, a movement called land back, water back. That's the idea that these federal lands, these public lands, should be returned to the tribes that were removed from those lands in the first place. And so there are sort of varying levels of repatriation that people are pushing for. You know, might be a specific area like the Black Hills should be returned to the Sioux Nation. And there's certainly a school of thought that all federal lands and all public lands and all national parks should be returned to Indigenous people. So there's a pretty broad arena there. We don't have everybody certainly in the same place on what should be done, but there's certainly a movement that says, look, this is actually our land and we should have it back. So that's something we see amongst our clients, certainly. The concept of free, prior, and informed consent, that's from the UN Declaration of the Rights of Indigenous People, which the United States finally signed on to, like 20 years after everybody else did. And that talks about if there's going to be a project that's going to impact tribal rights or resources, the rights or resources of Indigenous people, you should have their consent, their free consent, meaning that they're not coerced into it prior, before it goes into effect or before the plan is already in place. Get the consent of these folks and inform, make sure that you're providing all the information. A lot of times information about a project or about a process or about what chemicals might be used is protected information and people don't always get all the information up front. Traditional ecological knowledge, indigenous knowledge, I talked about that a little bit before. So, you know, federal policy, thinking about how to implement that in land use planning, land use management. Co-stewardship and co-management, you might have been hearing more about this lately. There's two professors out of Montana, Monty Mills and Martin Nye. They did some really great papers on co-management and co-stewardship and looking at all the places where tribes are co-managing federal lands and co-stewarding federal lands. And there's been a push to increase that, understanding that often Indigenous people stewarding lands in these, using these traditional ways have greater biodiversity. They're cleaner, they're just more protective and better use of that land. So there's been a push toward that in the federal government. There's a bunch of co-stewardship and co-management agreements either in place or in the process of being put in place. Bears Ears is probably the one that's most well known. Water quality standards, I mentioned that in the context of Fond du Lac and the Polymet mine. There's a rule pending that requires states in setting their water quality standards to consider tribal reserved rights, tribal off-reservation rights. So this is pretty interesting. We'll see how this shakes out, but this would be requiring all the states that have tribes with off-reservation rights to determine where those rights apply, what those rights are, and how the water quality needs to be protected to preserve those rights. Now I think there's like 25 states that filed comments against that rule. So we'll see how it goes. But that's something that's sort of percolating right now. And I'm very interested to see how that plays out. Josh mentioned the public lands rule, Bureau of Land Management, elevating conservation as a use on par with, extractive industries, mining, oil and gas. That's pretty interesting. And it provides a new mechanism for that, a conservation lease. So if folks want to just, preserve an area or restore an area, they can do that with a conservation lease as opposed to pulling out oil and gas with a mineral lease. So that's a pending rule right now as well. And a lot of these issues, it's interesting. I work with some Indigenous or some organizations that work with Indigenous people in Canada and Australia, some in South America. It's very interesting because we see these same issues all across the board. There are different legal schemes in place, but the issues are very much the same. And so it's really exciting, really interesting to see various iterations of these current issues and how they're playing out in other countries. Next slide. As promised, I'm going to briefly touch on current issues in energy development. We do see a lot of oil and gas development in around Indian country. And a lot of times both tribal and state governments are really dependent on that revenue. So we have tribes that are engaging in oil and gas development, mining, coal mining, things like that. And, again, these are governments that need to fund the government operations. And a lot of times it's the tribal entities or tribes in partnership with a private entity that are working on these extractive projects. Pipelines, you've probably heard a lot about various pipeline fights in the past 5 or 10 years. One thing I just wanted to illustrate here with this slide is the Enbridge pipeline line 3 coming out of the Alberta oil sands went right through Leech Lake Reservation. And the tribe has to provide a right of way, just like a federal or state land, or federal state government would have to provide a right of way on federal state land. The tribe provides the right of way through tribal land. And the Leech Lake band said, you know what, we actually don't want the pipeline here anymore. And so Enbridge had to go all the way around the tribe or all the way around the reservation. And so Red Lake and White Earth were like, well, actually, we don't like this. You're closer to our reservations now. And so we did put up a fight against that, resiting and rerouting the pipeline. Unfortunately, we lost, and that pipeline is operating now. But you can see that the tribal opposition, the tribal authority over their own land definitely had a major impact on that project, and definitely, increased the cost and increased the timeline for Enbridge's new pipeline. One thing we're seeing a lot of, both on federal and private lands, after the Inflation Reduction Act was passed, a lot of tax incentives for domestic production of minerals. We're seeing a lot of mining projects being proposed for those minerals to be used for the transition to a new economy. Lithium, cobalt, nickel, copper. We're just seeing that happening all over the place. Alaska, the upper Midwest, out west. And the problem for our clients is that a lot of those known reserves are really close to Indian country. So the concern is that we're trying to change the grid, we're trying to change the power source, we're trying to reduce emissions, but are we going to again be required to bear the brunt of that environmental degradation that is going to come when you pull out those minerals? So that's definitely a concern in Indian country, and that's something that we're seeing happen all over the place. Hydropower, that's another big hot button issue. Folks want to remove those dams, even though that's a fairly clean source of energy, because they're blocking fish migration, and the reservoirs created by dams that often have like really high methane emissions, which is, I had no idea. But there's just sort of like all of the clean energy development has, two sides. So just thinking about how to do that in time to minimize the climate impact, and yet sort of preserving all the things that we're fighting so hard to preserve, the water, the cultural resources, the public lands. And then clean energy development in Indian country, again, it's not something I work on, because we usually fight projects. We don't build anything, at least not my department. But there's a number of barriers in Indian country, just like these folks mentioned. Some of the barriers, transmission lines. A lot of tribes are really located in rural areas, really remote areas. And so it's a really high cost of transmission. If they were to have like a commercial or utility scale clean energy project, just getting that out to the market is kind of cost prohibitive. Oftentimes there's not a lot of capital to get that infrastructure in place. There's a bunch of money now being poured into it, but it's relatively new. So I think getting in the queue as far as being considered, I think that's something you guys touched on as well, can just really put tribes at the back of the line. So those are some of the things my clients are facing and folks that we work with in Indian country. And those are some of the ways that federal Indian law might impact your clean energy projects on federal land. Thank you.
Great. Thank you. Appreciate that from all three of you. A lot of questions come out of that. I'll start with a few and then we'll open it up. Mason, you talked a lot about the regulatory landscape for going carbon free and how important that is to your company. On a more practical level, there's also a lot of concern about the infrastructure and the aging grid. And some big news stories about California having issues, Texas a couple years ago with their winter storm. Just just want to get your reaction on, with the increasing focus on electricity and especially renewable electricity from renewable sources, being turned to for so many different new applications. What needs to happen with the grid, and what's your optimism or skepticism about will it happen in conjunction and in time?
Yeah, so we all of us have talked about transmission related stuff, and that I think is it's a big wild card in terms of, are we going to be able to achieve decarbonization, do it in a way that's equitable, that preserves scarce resources, or allocates them in a way that is that understands the competing puts and takes within the regulatory framework that we have, that's disjointed in so many ways. But it just, some facts. So transmission grid, if you think about, so again, driving down the highway, the big transmission lines, those connect to substations. They then step down the voltage of the transmission and it goes out into neighborhoods for delivery. And so the transmission grid itself is very old, average age of transmission line, 40 something years. And so the transmission network itself just needs to be, lines need to be replaced, need to be upgraded. And there's a whole kind of set of work there, which involves some permitting issues, but in most instances, those are existing lines. And so you're swapping out equipment and stuff. But then the question is, well, if you're going in and doing that work, should you think to the future and expand transmission lines? And there are some, different people throw around different numbers, and it depends on your analysis and your version of the crystal ball as you look out. But there's general agreement. You probably need between 3 to 5 times more transmission lines than you have out there. And so it's rebuilding our system multiple times over and doing it in the next 2 decades at a time when there are competing concerns, right? And so the thing that I worry about is all politics are local, right? And so when you have a project that is going through an area that is going to be impacted, how to understand that impact and make sure that the local community understands what this project is about, right? I mean, it's great for us to well, they're just competing considerations, right? Preserving something that ultimately is going to be damaged 20 years from now by increasing severity of storms, be it, winter polar vortexes or floods or tornadoes, or like the climate impact of where we are heading if we don't really, really ramp up in terms of what needs to happen on the grid and the generation system. But then understand, I mean, that has real world impacts on people. And so how do you take that into consideration, make the best decisions that you can, having both the near term and the long term in consideration? And it's just, it is a huge challenge. Average time for a big transmission line from planning to actually come online, about a decade. And so if we need to be doubling or more our existing transmission system and doing it in the next 25 years, and it takes 10 years to bring on one transmission line, it is not achievable in the current structure, which then means that we all need to be saying we are in a mitigation or an adaptation world. We are not in a mitigation world. We need to get used to the fact that we are going to have increasing outages. We will have more severe weather because we are not able to achieve what we need in the power sector to support decarbonization of the economy. It's just an unavoidable fact. And so we're fighting against that, right? But it's complicated.
Josh, do you have any reaction? How do you do the smart from the start in this environment where there's also all these goals to get to carbon zero?
I mean, well, no, if you had the answer, you would be because everyone's looking for the answer. So NRDC's big push is in this space. There is obviously a lot of asks into Congress to and there are various ways to, more aggressive or less aggressive ways, but, our view is that there's a lot that can be done with transmission to improve the situation, the regulatory situation, the permitting situation, without gutting environmental protections. And they're at the same time, because Congress is not something to pin hopes on, there is a lot that agencies could do via new rules or the authorities they have that they're not fully exercising to make more happen. The on the ground situation, I kind of gets back to what I was saying, and I think it's hard for developers because it's very expensive, it's very time consuming, but going in as early as possible to hear those concerns and to hear what would a community maybe want. And there's a whole host of push for like community benefit agreements where that payoff is seen. Where I'm from, the big thing is like, well, we don't get to use that electricity, so why should we let it go through here? Or why should that project be built here? I mean, electrons flow every direction, and that's not a reflection of what's actually happening with the grid or how electricity is distributed or used, but for a person on the ground, that does feel that way. It's like, you built that wind turbine next to my house and someone 300 miles away is using it. Why in the world would I support that? So figuring out, how does the community benefit aside from just taking on the impact is crucial. A lot of different, but there's just a lot of, and that gets to the point about local politics.
Everything's local. So just to stick with you and picking up of something that Gussie mentioned, electric vehicles are growing exponentially because of mandated mandates and I think also automakers really feeling like that's their corporate duty to be making more and more EVs. I think citizens are feeling that way more and more. Along with the grid issues are the fact that when you're building batteries, you need a lot of critical minerals. And there was a recent, I think it was a New York Times article that sort of laid out where most of the minerals are globally and who they're controlled by, and they're not controlled by the United States. But there are some critical resources here in the US. And there's more and more interest of, we need to be able to have our own supplies. Just would like to get your thoughts on how do you balance something like mining, which is very intensive, and you do see it, unlike some of the oil and gas work, as you were noting, that's underground. Mining can be very disruptive of the surface. How do you balance that with conservation and federal lands?
Are you asking me?
Or you, yes.
Yeah, and I'm sure Gussie has an opinion.
Yes.
So there's a lot of dynamics at play. Obviously, China has moved well before everyone else to capture the global supply chain of minerals, and now countries, especially the US, are confronting that reality in various ways. Whether we'll be successful remains to be seen. But from my view, so I think there is no question that some domestic mining will need to happen. But right now, a lot of the conversation is, and I think policy decisions are geared toward onshoring everything. We can do this all in the US. And I don't think it's realistic. I think the reality is for some minerals that we need, the US is not the best place to mine them. And not because of a NIMBY reason, it's simply our deposits aren't always the best. We don't necessarily have the best lithium deposit or the best nickel deposit, or you name it. And where that's the case, we should be working with our allies who have hopefully high environmental standards. If they don't, we should be pushing them for those, or pushing for some sort of international system to monitor those kind of standards. And then we're in the domestic sphere. I mean, our big push is for mining reform. We think mining can happen more responsibly, but we are operating under a law that is 150 years old, and it was designed to facilitate Western expansion. You can go out on, you can do this today. You can go out on federal land that's open to mining, which is most. You can stake 4 stakes in the ground and you have a mining claim. And then if you discover minerals, you then have the right to mine it, and it costs like $150. It's crazy. And that law comes with very, very few environmental safeguards. Regulations are very weak. And so our big push is, hey, BLM, write some mining regulations. Hey, Congress, there are some very low-hanging fruit reforms that would allow mining, create a leasing system, create a kind of not very expensive, but a royalty system. You also don't have to pay the federal government any money for minerals you extract on federal land, which is different than all other extractive industry. And, require some environmental safeguards so that drinking water, and again, remember, this is happening in the West. The West is very water constrained and mines use an enormous amount of water. You need to have those protections in place. Get those protections in place, site mines a lot better than we currently do. And yeah, I think domestic mining can happen and grow. But right now, industry is pushing for deregulation. So there's a huge gap between kind of where, we aspire to go, where industry aspires to go, and certainly where kind of national policy wants to go. Yeah, but I think it can be done. It's just, I don't know when the meeting of the minds will happen, and hopefully it does begin to happen. But I'm sure you have more to add to that.
Yeah, no, definitely with the mining law reform, like you said, there's always this sort of narrative that like, oh, if they do it somewhere else, it's going to be dirtier. Well, our laws aren't that great, so again, the push for international standards and for where these materials and how they're sourced. And certainly pushing for a circular economy, greater requirements for upfront production so that things are easier to reuse and recycle on the back end. That would be helpful. And just another piece is that there's really a push toward, extracting these certain minerals. The technology is changing so rapidly. We've seen other times when there's been a big push for a certain mineral, then the sort of the market, the bottom falls out of the market, and then there's not the returns that were anticipated, and then there's not the cleanup that was supposed to happen. And there's things like that I have concerns about. You're sort of like, are we really going to do the same thing again? And yet, we can't deny that there is a need for some of these materials. There are certainly funds out there for new technologies. But certainly what I would say, like, rushing into these destructive projects is not a good idea. And there are just some places that shouldn't be destroyed or shouldn't be subject to degradation. And so understanding that, like, can't happen everywhere, I think is key.
So one sort of theme is the need for partnership at a lot of different levels. And some think that we really need a price on carbon in order to incentivize that to happen. Just quickly, views on, we're all sitting here in Washington, D.C., views on, is that going to happen in the next 5 to 10 years? No.
I defer to you.
I don't see it.
Yeah.
So the carbon border mechanism is very popular in a bipartisan way. So maybe some there's major equity concerns with prices on carbon, of course, because it's likely to impact low-income people more, depending on how it's implemented. So that's our big concern. But yeah, hard to see.
Hard to say.
I think
We'll open it up for some questions. And okay, great. All right, Grace, we've got some questions. We have one right here in the front row.
What about federal transmission corridors? Help?
Just generally, yeah, I think they help. So federal transmission corridors are a concept that came, I guess we're going back about 10 years ago. Like I said, traditionally, the siting of a transmission line has been subject to, if on federal lands, federal regulation, but if not on federal lands, then it's subject to state review. And so the permitting of a transmission line not on federal lands, to the extent otherwise approved in the federally regulated system. So this transmission line is needed to bring on, X amount of projects or serve Y amount of customer demand. Then you've got approval at the federal level for the planning and the cost allocation, the cost recovery of that. But then the company goes out, okay, I want to build the thing. I got to get a permit to build the thing, and then goes to the state and say if it's a transmission line, which is primarily intended to, and to use the example, to support wind that's located, out remotely and it's moving power to city centers, right, where it's going to be used, then the local community is like, I'm not going to permit that land. Where's my benefit associated with that? All I get is the damage associated with it. And so there was a change to the federal statute, which provided backstop siting authority for the Federal Energy Regulatory Commission in these instances where the state denied a permit, but only if the transmission line was in a nationally designated corridor. With DOE designated the authority to, or signed the authority to identify these corridors. So what are the kind of high demand areas for transmission under a set of statutory criteria? And then if the transmission line is within one of those corridors, then flip over to FERC in the event that the state denies the transmission line. FERC has the backstop siting authority. Ended up getting tied up in a bunch of litigation because of states' rights issues, right? I mean, that is taking a state issue and moving it to the federal government. The designation of the corridor itself, the way that the DOE went about identifying the corridors was challenged. That got overturned and sent back to DOE. FERC issued regulations for here's how, if we ever find ourselves in the situation of getting one of these transmission lines, here's how we're going to interpret statute and apply it. That regulation got thrown out because FERC was proposing or adopted the rules saying we are going to interpret a state's failure to act as denial, because state could just sit on an application and never approve it. And so does that end up a black hole? Like we don't have backstop siting authority over that. And so Congress ended up updating the statute to clarify that FERC has authority in the event that the state fails to act. DOE has re-upped its corridor designation analysis, but it's still a disconnect between the two agencies where DOE is saying, okay, well, here's the areas that this authority would trigger. It's going to click over to FERC in the event that there's some project out there that falls within these corridors. And then FERC now is finalizing regulations to be able to provide, issue that permit in the event the state fails to act or denies. So no project has ever been through this process, even though the statute's kind of been around for 10 years now, because there's been constant litigation on even the rules to get to that point, much less before you actually have a project that moves through it. So it just highlights, how difficult these issues are. There could have been a different way to interpret that statute. DOE could have delegated to FERC, or FERC even the other way around, but structures kind of aren't that way to say, well, we're going to integrate. We've got back to that regional map that, I had the big bubbles of the multi-state regions. There are planning activities that occur, transmission planning activities that occur. So you could line it all up and say, well, to the extent that the region has determined that this transmission line is needed for define the criteria, then that's going to be nationally designated because it is a federally regulated entity engaged in the planning. And then in the event that that project, which has been recognized as having a federal need through the federally regulated process, does not make it through the state planning process, there's an avenue to come to FERC to actually get that project done. That's not the way that it was implemented because there are multiple agencies who have their own jurisdiction and their interests in this area. So we'll see if it ever turns into a viable option for a transmission line, but it's there in theory now.
Interesting, thanks.
Yeah.
The major themes of these presentations were about decarbonized electricity and clean energy, and they're not synonymous. I'm curious why the word nuclear was mentioned once in the whole presentation, but the first set of slides all said Constellation on the bottom. Constellation is Exelon. Exelon runs more nuclear power plants than any other enterprise in the United States. You know, why was nuclear just avoided? It's enormous in the context of this whole thing.
Sure, I mean, I can take that. Nuclear is, yes, so Constellation Energy is the largest owner and operator of nuclear in the country. Right, 1 out of every 10 clean, zero carbon, emissions-free electron on the system comes from one of our plants. We also own hydro, wind, solar, you know, A to Z, but 90% of our output is carbon-free, and we're the largest power producer in the country. And so, but a bulk of it is nuclear. So we certainly don't shy away from, you know, nuclear is emissions-free, largest source of clean energy in the country.
Except for the radioactivity.
So there is waste associated with the used fuel, which we take care of, right? We know where every gram of our waste is. We're not putting it in the environment. It is secure. We would like to have a federal repository where we could be combining that into a secure space. That has not made it through the political process. So we are taking care of our waste. And if you take all of the used fuel across the entire kind of nuclear production industry for electricity, ever since the 1950s, it fits on a football field, 10 yards high. So yes, it's real. Yes, we need to take care of it. Yes, it's a serious issue, but it is one that we know how to do and we've done for decades. And we're going to keep doing it because it's a necessary part of our environmental protection system going forward in terms of decarbonization. You cannot meet a decarbonization challenge without preserving existing nuclear and in all likelihood expanding it.
Well, in terms of climate change, every single nuclear power plant is parked right next to a river or a lake or the ocean because it requires enormous quantities of water for cooling. What's going to happen if that water goes away?
Then if there are water limitations, then just whether it's for nuclear operations, whether it's for mining, for the critical minerals needed for other sources of power, like we will manage through that. And to the extent it limits our operation, we will have less carbon-free output in order to provide the market, which is going to be a problem, which is why we are fighting for decarbonization to not have those impacts that we're in an adaptation world that's further limiting the options that we have.
And part of, I mean, it's again, part of, I can think the theme here and certainly the theme among, you know, my clients who are often wearing multiple hats in the energy world. It is what a lot of people say in terms of, you know, all of the above, you know, we don't put too much in one bucket versus the others, you know, because everything has an unintended consequence in my view.
I mean, there are trade-offs in everything. I mean, all the issues we've talked about in terms of land use and community impacts. I mean, if we don't solve this larger challenge, there are going to be land use and community impacts of that as well, right? In the same way that if in the energy space, what we're doing in terms of trying to develop our resources and our capabilities are leaning too much in one direction, like it's all trade-offs. If they were easy, I think you said, like, if they were an easy answer to this question, like we would have done it. Yeah, it is, there are no easy answers.
Well, and I was, you know, looking at everyone's experience up here, and I know, Josh, you've done a lot of forest work with forest management, and obviously we all, you know, really, for me at least, the first time we're impacted by that 2 weeks ago when we had the smoky days from, you know, the smoke up in the Canadian fires, from the Canadian fires. There's a lot of moving parts here, not just within our borders. Okay, one more question is what I've been told.
Thank you all three of you for the presentation, very insightful. Mason, you talked about FERC, how or states sometimes want to subsidize and support renewable energies, and then FERC comes in and says, no, they'll let disturb our federal rate making, etc. And FERC also doesn't have the authority or mandate to consider decarbonization, renewable energy generation. So what's needed to change that? Do we need to change the statute that FERC is applying, or And if so, is that gonna happen anytime soon? What do you think?
Yeah, so on the current set of regulations or the rules regulating these markets, FERC has backed away from that, unwinding the state support. But, you know, so a minority of the current city commissioners would put them back in place if they could, right? So it's just back to the change of administration, who has control and who has the votes. But in terms of resolving this conflict going forward, because, you know, over 2/3 of the states have clean energy mandates, or goals for, you know, effectively completely decarbonizing their power sector. I don't see that going away. And so open question whether we get federal policy, that would be the direct answer to the question. If the Federal Power Act were changed to the primary statute of jurisdiction for FERC is the Federal Power Act in the electricity sector and the Natural Gas Act in the gas sector. If the Federal Power Act were changed so that standard I mentioned, just and reasonable and not unduly discriminatory, you know, also had an environmental component, then that would take care of it, because the commissioners would say, well, I now have a statutory mandate to align these two things. But right now, they don't. And so they're in their wheelhouse and their silo, and environmental regulators are in theirs, and they talk to each other, but they have different missions and different goals. And the same thing's happening at the state level. There's a disconnect between the energy regulators because they just have different statutes, different goals, different constituencies, and the environmental regulators, same thing. And then at the state level, the energy regulators are not necessarily talking to or doing the same thing as the environmental regulators. And you need to get everybody together on the same page. Otherwise, these disconnects are just gonna impede, you know, achieving the long range goal. It's gonna make it harder for communities to get, you know, engaged. It's gonna make it harder to figure out how to allocate scarce resources and things like land. But it's full employment for lawyers, for anybody that's interested in the area.
And I'm guessing likelihood of congressional activity is quite low.
I mean, you'd have to have agreement in Congress
Yeah.
on climate issues.
Yes, so quite low. Not to be a pessimist.
Yeah.
But we'll end on, thank you all for spending 2 hours with us, and thank you all for your presentations.
Thank you so much to our wonderful speakers for joining us today. Thank you, Gussie, Josh, Mason, and Susan. We so appreciate your time. Thank you to our audience. Please continue to tune in for our next few summer school sessions. We're now halfway through, so our next one, we are taking next week off. So our next one will be 2 weeks from today for the Clean Air Act. So thank you again.